Good evening, ladies and gentlemen, and all our distinguished guests. My name is Mimi Zoe. I am a professor of law at UNSW Law and Justice, and I'm very proud to be leading our School of Private and Commercial Law. I begin tonight's event with acknowledging the Gadigal people of the Eora Nation, who are the traditional custodians of the land on which this event takes place tonight, and I pay my respects to their elders, both past and present. I also like to welcome any Aboriginal or Torres Strait Islander guests who are joining us tonight. So, the Margaret Stone Lecture, co-hosted by the Faculty of Law and Justice at UNSW and Herbert Freehills, with the support of the Federal Court of Australia, celebrates the remarkable life and legacy of the late Honourable Margaret Stone AO. Margaret Stone's journey to the legal profession began at Holy Cross School in Sydney, followed by degrees in English, philosophy and law, graduating with honours and the Supreme Court Prize at the ANU, and later a Master of Law at Yale. Margaret's career spanned academia, private practice, and the judiciary. She served as the beloved professor at UNSW Law for 15 years, where her intellect and warmth left a lasting impact on students and colleagues. Her transition into private practice saw her rise to partner at Freehills. She specialised in commercial property, infrastructure and development, commercial finance and taxation. And she took pride in sharing her knowledge as a mentor to many. In 2000, Margaret was appointed a judge of the Federal Court of Australia, where she served until retirement. Post-retirement, her dedication extended beyond the bench as an independent reviewer of ASIO's adverse security assessments, and later she became Australia's Inspector General of Intelligence and Security. In recognition of her service, she was appointed an officer of the Order of Australia in 2019 and received a Doctorate of Laws, honoris causa, from UNSW in 2022. Margaret devoted her life to the law, guided by the rule of law and its importance to society. Tonight, we honour Margaret's legacy, her contribution to legal education, and her exemplary service to the judiciary and public administration. I would like to extend a warm welcome to Margaret's family joining us tonight, including Professor Jonathan Stone and their daughters, Professor Adrian Stone and Professor Emily Stone, and their partners, David and the Honourable Justice Graham Hill. Welcome. Now it's my pleasure to welcome the Honourable Justice Nye Perram to present this year's Margaret Stone Lecture. Justice Perram was appointed to the Federal Court of Australia in 2008. He currently serves as the President of the Copyright Tribunal and is a former part-time commissioner of the Australian Law Reform Commission. Before his appointment, he practiced as senior counsel at the New South Wales Bar. His honour holds a Bachelor of Civil Law with distinction from the University of Oxford and a LLB honours from the University of Sydney and a BA majoring in pure maths and English literature. He commenced legal practice in 1993 and was called to the bar in 1994. I'm told that beyond his impressive legal career, Justice Perram is a fan of Tom Holland, Dominique Sandbrook, and poached eggs served with hollandaise sauce. So, if you ever need a legal opinion while discussing the latest Spider-Man show over brunch, he's your man. Please join me in welcoming the Honourable Justice Nye Perram.
Well, thank you all for coming this evening, and a warm welcome to the Family Stone Ensemble. It's very nice to have you here. It's a great honour for me to have been asked to give the second Margaret Stone Lecture. I didn't have the honour of meeting Margaret until I was appointed to the Federal Court in 2008, although I had heard much of her. But after I was appointed, we were colleagues for about 4 years, and we sat on, I think, maybe 10 appeals together. She retired in 2012 to take up a number of positions, culminating in the important and interesting position of Inspector General of Intelligence. The appeals we sat in were mostly to do with equity and tax. One of these was a case called Bamford, which concerned the tax treatment of the income of trust estates, which sounds dry but was incredibly fashionable at the time we sat on it. And we wrote a joint judgment about it, and we were upheld in the High Court, which was always nice. We also sat together in Grimaldi and Chameleon with the late, great Paul Finn, and we produced a very, very long judgment, which by coincidence seems to have dealt with almost everything that Paul wanted to say about fiduciaries. Margaret was a truly great property lawyer, but her work was across the full breadth of the court's jurisdiction. And more than that, she was an absolutely delightful colleague, at once brilliant, self-effacing, humorous, and just a little bit naughty. I regard myself as deeply privileged to have met Margaret and to have had the honour of serving on the court with her. The fact that this lecture was inaugurated shows that my views about Margaret are not idiosyncratic, but rather ubiquitous. So this speech started off in my mind as a discussion of the various ways in which private assets could be subject to rights of access in favour of the public, which at the time I formulated the topic sounded kind of fun. Since there I've undergone a little bit of mission creep, and the topic has transformed without changing utterly into a discussion of access regimes and the regulation of certain categories of monopolies. And by monopolies I mean both those which are created and those which come into existence via natural forces. As we shall see, historically the state has itself had a very significant role in creating monopolies and continues to do so today. I'll be returning to these modern monopolies, but for example, consider the modern phenomenon of state concessions to operate toll roads and concessions or tax advantages to run casinos and poker machines. On the other hand, sometimes a monopoly can arise naturally without the granting of a concession by a government and just from the nature of an asset. So, for example, a stock exchange or a wharf or some railway lines are examples of natural monopolies. Before launching into the substance of what I wish to say, we should perhaps say what a monopoly is. Fortunately, after 100 years of competition law and economic scholarship, we have surprisingly subtle definitions of monopolies, which are commonly referred to in litigation. In effect, there's an interrelationship between the concept of a monopoly and the concept of a market, and in fact, the two turn out to be two sides of the same coin. A market is, in short, something which can be monopolised, and if it can't be monopolised, it's not a market. To answer this question, economists like to theorise about what would happen if all the firms in a proposed market were owned by one firm. And they do this by asking themselves, it's a very grand title, they ask themselves the hypothetical monopolist test. And the question is, if that firm lifted its prices, would it get away with it? Or would the customers go elsewhere? And if you get an affirmative answer to that, what you have is a monopoly, and if you get a negative answer, it's not. So a good example I always use is imagine the proposed market, and in formulating this example, I very much have the Chief Justice of New South Wales in mind, who I'm pleasure to see is here tonight. I contemplate the proposed market of restaurants on the eastern side of George Street. Now, if all these restaurants were owned by the same firm, let's say Merivale, would he be able to double his prices, including on the Kingfish crudo, and get away with it? And the answer is no, he wouldn't, because people would step from the eastern side of George Street to the western side of George Street. So we know from that little mind game or mind experiment that the proposed market of restaurants on the eastern side of George Street is not a market because it can't be monopolised. I mention these formal matters because more than a century of competition law has left people, and particularly competition lawyers, with a sort of innate hostility to monopolies. Now, I'm not here as an apologist for monopolies, but what I want to do this evening is to attempt to show that properly regulated, some monopolies can at least, in some circumstances, serve genuine purposes of social good. Because the price of goods is a topic which extends across the whole sweep of written human history, one can trace monopolism and concerns about it back into the mists of time, pretty much as far back as you want. Monopolies historically have often been closely linked to patronage and clientelism. Those close to the king were often rewarded with, in effect, monopolistic grants. For example, this one interested me, Tiberius granted members of the ruling elite, principally senators, monopolies on shipping, salt, marble and grain, and the Han dynasty in China granted extensive monopolies also on salt and iron. So Crown grants of monopolies over goods is nothing new. But because we don't have all night, I want to pick up the monopoly thread just before the Industrial Revolution in England. Prior to 1624, or perhaps 1623, we shall see, one of the prerogative powers of the Crown was the power to grant monopolies by letters patent. I say letters patent because patent lawyers are very keen on saying the word patent rather than patent, but many people do say patent, but I'm going to say patent this evening. It's always fun in a patent case when a new player turns up and says patent and everyone goes, oh dear, that's amusing. The first English patent for a monopoly seems to have been issued to a Flemish merchant by Henry VI in 1449. It granted him a monopoly for a method of making stained glass and to provide the stained glass windows for Eton College. The use of a patent for a method of production was not a particularly English innovation. The Italians had been doing it since the 14th century. An aspect of the grant of monopolies was that they provided the Crown with very considerable sources of revenue and did so in a way which did not require parliamentary approval. This led to abuses as the Crown was incentivised to grant increasingly large numbers of monopolies over salt, grain, wine, coal, clothing, mining, and the production of saltpetre, which is an important component in the manufacture of gunpowder. Each patent for a monopoly was granted in return for a substantial contribution to the sovereign's pockets. In effect, what was created was an indirect tax on goods disguised as a monopoly. The genius of this was that whilst people got very upset by the inflated prices that the monopolies caused, they didn't blame the Crown, they blamed the monopolist. Worse than taxation without representation, this was taxation without detection. However, the Crown's widespread use of what I'm sure Donald Trump would have called these beautiful monopolies eventually created friction, first for Elizabeth I and then for James I. By 1600, the topic had become very, very politically fraught. By 1621, Cook had drawn up a bill substantially to limit the grant of monopolies by the Crown and curtail this practice. After some struggles, that bill finally passed the Parliament on the 29th of May 1624 and is known as the Statute of Monopolies. Now, there'll be two types of people in the room. There'll be those who've heard of the Statute of Monopolies 1624 and there'll be those who didn't, who haven't, probably quite a few of you. But the Statute of Monopolies is a very famous statute. Let me tell you, before we go into it, two fun facts about it. First, with apologies to any patent lawyers who are in the audience, Section 6 of the Statute of Monopolies is in force in Australia, in effect, and in fact is at the heart of some very important current debates, which I will touch on shortly. Secondly, the statute is sometimes called the Statute of Monopolies 1623, but it is also sometimes called the Statute of Monopolies 1624. The statute was passed on the 29th of May 1624, but at that time, acts commenced at the start of the parliamentary term in which they were introduced. This session of Parliament began in February 1624, but before the introduction of the Gregorian calendar in 1752, the first day of the year was Ladies' Day, which was the 25th of March. So at the time the Act was introduced, it would have been regarded as having commenced in 1623, but after 1752 we would consider it to have commenced in 1624. The fact that this famous statute seems to have been passed in 2 different years is an enduring menace for associates who caused great stress by it. The statute curtailed, but did not eliminate entirely, the prerogative power of the Crown to grant letters patent for monopolies. Most of the former offensive monopolies on wholesome things like wine were abolished. In modern times, amongst intellectual property lawyers, the statute is very famous because one of the few monopolies it left in place was the monopoly to exploit an invention. And Section 6 of the statute permitted in certain circumstances the issue by the Crown of letters patent granting a monopoly to use a particular invention. These kind of patents had actually existed before the statute, so you often read articles saying that the statute is the source of patent law, but that's probably a little bit overblown. In time, the word patent has come to be almost exclusively identified with the single kind of monopoly for an invention, and the former rich ecology of patents for various other monopolies have passed out of the public mind. The critical innovation in Section 6 of the statute was the idea of making the monopoly a reward for the exercise of inventive skill. And that is to say, instead of using the monopoly as an instrument of Crown patronage, the monopoly was instead linked to the promotion of innovation. Inventors would come up with new and useful manners of manufacturing items and be rewarded with a finite monopoly of 14 years in the first instance to exploit the invention. It took some time for this idea to take off, largely because it was incredibly technical when it first began. But by about the middle of the 18th century, 100 years later, it had really begun to take off. It's probably not a coincidence that the coming into existence of a functioning patent system seems to have corresponded with the commencement of the Industrial Revolution and subsequently later waves of technological advancement, which continue right up to today. In effect, the concept in Section 6 of granting monopolies as the reward for innovation weaponise the forces of capitalism to pursue innovation. Monopoly is at the heart of that weaponisation. The point for present purposes is to underscore that whilst competition lawyers, and perhaps the public generally, instinctively regard monopolies as bad, a more nuanced view is that some of them can actually be used to harness quite substantial social goods. Before passing on from the statute, it's useful to note its enduring relevance in Australia. It's not possible to obtain a patent for an invention in Australia unless it constitutes, and this is the language of the statute, a method of manufacture within the meaning of Section 6 of the Statute of Monopolies. This is the literal requirement of Section 18 of the Patents Act. The provision has been at the heart of some of the most contentious contemporary cases about patents. For example, it was Section 6 which determined whether it was possible to have a patent for a human gene as part of a test for breast cancer in Darcy and Myriad. Answer, no. And at the moment, there is an ongoing debate yet to be resolved about the extent to which computer programs can be patented. And again, that is directly a function of Section 6. The last time that question was before the High Court, it led to a 3-3 split, and by force of statute, the upholding of my judgment in the full court below. It's a very, very sound statute. So that's one set of monopolies. Arising around the same time is another, which is the monopoly of copyright. The history of how copyright for authors arose is quite a complex history connected with the printing press and the Crown's increasingly aggressive efforts to control what could be printed in books within the realm. Book printers were granted monopolies over the printing of certain books in certain geographical locations. By these means, what was printed could be controlled by the Crown. The importation of foreign books was banned. The monopoly which the printers had over the printing of books became mired in political issues about censorship, and eventually, after a great deal of commotion, the monopoly was abolished in 1694. Successive efforts by the book printers to get the monopoly back were unsuccessful until they had a cunning plan and changed tack and began suggesting that the monopoly should be given not to them but instead to authors to encourage people to write literature. Under this ruse, the printers were successful and the monopoly was restored, but this time given to the authors rather than to the book printers. That finally bore fruit in 1710 with the Statute of Anne, which is the first copyright statute. But you'll see it's got the same idea, which is the linking of a grant of a monopoly to some social good you want to encourage, invention or literary or artistic endeavour. Now, these early monopolies are effectively all forms of intellectual property. And in fact, if you think about it, you'll see that almost all forms of intellectual property are actually species of monopoly. Think, for example, of trademarks, passing off designs, circuit board layouts, and of course that most well-known of intellectual property statutes, the Plant Breeders' Rights Act. At the heart of all of these rights is the right to exclude other people from its exercise, and that's what makes it monopolistic. But contrary to the impression you might have, this is not a lecture about intellectual property. There were many more tangible monopolies used through the 17th and 18th century to achieve particular desired outcomes. Many of these involved the grant of concessions to carry out particular activities, accompanied quite often by a grant of legal personality in the form of a joint stock company. And probably the most famous example is the East India Company. So the charter which created it didn't just give it legal personality, but it awarded it a monopoly on English trade with all countries east of the Cape of Good Hope and west of the Straits of Magellan. The monopoly was protected by what a modern economist would call very high barriers to entry. A trader who sought to trade against the East India Company east of the Cape of Good Hope was liable to the forfeiture of its ships, all of its cargo, and the imprisonment of its crew. So that is indeed a high barrier to entry. Perhaps at a more mundane level, a great deal of infrastructure was constructed in the United Kingdom using monopolies as well. These included railways, canals, roads, and lighthouses. The statutory structures usually involve the grant of a monopoly concession to construct the asset and then levy fees for its use. Armed with the concession, the grantee would then raise the funds to construct the infrastructure in the bond markets, and the stream of fees was used as collateral for the bonds. Similar arrangements arose in the United States, particularly in relation to railways. You can tell a lot about a culture and an economy by looking at its law reports. If you skim the 19th century English and American decisions, you'll see that they are festooned with cases about railways and canals. And I think this reflects how the growth of both economies was a central cultural pursuit. There's an interesting Antipodean twist on this, which has been, I think, very well exposed by Professor Will Bateman in a recent article of his entitled Federalising Socialism Without Doctrine. One thing you'll notice about Australia's infrastructure development is that it appears to have been carried out by colonial governments rather than private interests, as was the case in the United Kingdom and the United States. Will suggests that the reason for this is that colonial governments were backed by the Crown and therefore had access to cheaper funding in the London bond markets than ordinary entrepreneurs, and hence their cost of capital was much less. So it became simply more economically efficient for colonial governments to build infrastructure, and that's, at least according to Will, that's why we have such a history of state ownership of assets in Australia. Indeed, Will puts it a bit more highly than that. He says basically, without anyone realising it, 19th century Australia was a socialist paradise. It's just that no one knew. It's interesting. He makes the point that when you look at things like the power to regulate railways and rivers in the Constitution, you have to read that against a backdrop which includes that in the 1890s, all infrastructure was owned by states. So it has a sort of different complexion once you understand that. Anyway, that's a quick canter through a range of historical monopolies. You might add to that list modern concessions to conduct toll roads, which are particularly fashionable here in Sydney, and concessions to conduct what would otherwise be unlawful gambling operations, and licences to construct monopoly infrastructure such as energy and telecommunications networks. So what about the regulation of these monopolies? Some of the monopolies I have described are capable of yielding social and economic benefits, and we need them. We want drug companies to develop drugs. We want some authors to write books, and we want the construction and operation of road and power networks. But each of these is inherently monopolistic. The problem is not monopolies per se, but rather the manner in which the rights of private property involved in them are regulated for the public benefit. We want to prevent the monopolies sliding back into the practice of patronage, and we want to keep it in harness for the public good. Viewed this way, I think it is simplistic to think that open markets are inevitably good and that monopolies are inevitably bad. In the remaining half of these remarks, I want to focus a little more on monopoly regulation and to point out some features where it is working well for the public and some others where it is sliding back in the direction of patronage. So let's start with something which is going reasonably well. This is the regulation of assets which exhibit in their inherent nature monopolistic qualities, or markets which exhibit monopolistic qualities. So the best example of these is large-scale infrastructure assets such as power distribution networks, telecommunication networks, railways, some ports, that's a bit controversial, and other networks. To that can be added the kinds of services which are carried across those networks. In Australia, this is all quite well regulated. It has been for some time. The scheme in Australia is put in place by Part 3A of the Competition and Consumer Act. Part 3A deals with the circumstance that the owner of an asset having monopolistic qualities, for example a railway line, is in fact involved in two different businesses. One is the business of owning the railway line, and the other is the business of moving trains along it. What Part 3A seeks to do is to permit other firms to enter the market and compete with the railway owner as a provider of train services. So effectively, if Part 3A applies, other people can use the railway line. Part 3A does this by permitting certain assets to be declared, and once they are declared, other service providers are able to access the assets for themselves. Once declared, the asset owner must grant access on terms which are to be agreed, and failing agreement, arbitrated. These access disputes are usually very complicated and involve setting an access price, which prevents monopoly rents from being extracted from the access seekers, but which also sufficiently rewards the asset owner for investing in the infrastructure in the first place. If you've been involved in any of these cases, you'll know about WACC formulas and weighted average cost of capital and gamma and beta. It's a nightmare. It's essential in this price setting process, however, that the prices are set in such a way that firms still think it's worthwhile to build railway lines. If you set the price too low, people will just stop building these things. In short, we must not kill the goose which lays the golden egg. We just want to try not to overfeed it. Importantly, both the question of whether an infrastructure asset should be made the subject of Part 3A and the allied question of the terms upon which access to it is to be granted once it has been declared are subject to the ultimate review of the Competition Tribunal, the principal members of which are judges of the Federal Court and who are highly independent of the government. So that's the general infrastructure regime for Part 3A. There's a bespoke scheme for telecommunications in Part 11B, but it's not really that different. So what about state-granted monopolies, or Commonwealth-granted monopolies? Here we're confronted, I think, with the curate's egg. Some state monopolies are very well regulated, but others, such as gambling and road concessions, may be more problematic. When I use the word state here, I mean government. So just starting with two of the government-granted monopolies I mentioned before, let's start with copyright. Those of you who are not intellectual property lawyers may be immediately asking yourselves, what is there to regulate about the monopoly of copyright? The answer is quite a lot. Let me introduce you to the arcane world of the Copyright Tribunal and to show you some of the pipelines under the pavement which very few people notice. To understand this, it's necessary to understand a few different copyrights which exist. There's quite a few of them, but I'm just going to mention three. The first is the copyright in a literary work, such as a book. The second is the copyright in a musical work, such as a song. And the third, which is a little bit less common in the public mind, is a copyright in the performance of a musical work, that is an actual recording. So the second and third are quite closely related, but they're not the same. So whilst Beethoven is well out of copyright, a performance by the Sydney Symphony Orchestra of one of his symphonies, that performance, or a recording of that performance, is a copyright work in itself. A more contemporary example is probably afforded by the song written by Prince, Nothing Compares to You, but most famously performed by Sinead O'Connor. If you want to sing Nothing Compares to You at a public function like this, you'll need the permission of Prince's estate, but if you want to play the Sinead O'Connor version on the radio station, you'll need the permission of both the estates of Prince and Sinead O'Connor, and that's because you'll be using both copyrights. The collection of royalties for uses of copyright is generally conducted on a collective basis through mysterious and arcane bodies known as collecting societies. These are generally not-for-profit companies limited by guarantee, which exist to represent the interests of a particular class of copyright owner. They're licensed to operate by the Copyright Tribunal. For example, the collecting society which represents the owners of copyright in literary works is known as the Copyright Agency Limited, or CAL. If you're an author, you will almost certainly be a member of CAL, and it will seek to collect royalties on your behalf from those who use literary works. As an author, you'll probably have your own arrangement with your publisher, but CAL will collect royalties for you from other exploiters of your work, such as university libraries and schools. The agency which represents the owners of copyrighted musical works is known as PPCA, and the agency which represents the owners of copyrighted musical performances is known as APRA. Often the owners of these copyrights can be very large entities who run the music industry, such as Sony Music. But Sony and entities like it all belong to APRA and to PPCA. There are other collecting societies too, such as those focused on film rights and visual arts, and so forth, but there's no need to mention those. Although these entities are not for profit, some of these bodies are economically extremely substantial participants in the economy, although almost entirely invisible. APRA, for example, through international arrangements, controls in Australia all of the copyright in all of the sound recordings in all of the music around the world, with a few very minor exceptions. If you hear it on radio or on TV or on a streaming service, APRA is there, even though you don't see it. It's there because those who broadcast or communicate sound recordings to the public must have a license to do so. So, for example, if Channel 9 broadcasts a news segment about youth culture in St Ives, and incidentally there is a recording of Frank Sinatra singing I Did It My Way playing on a radio in the background, Channel 9 infringes the copyright in the recording and the song unless it has a license from APRA and PPCA. Both offer to the industry, very generously, blanket licenses to broadcast or communicate any and all works in their repertoire. So by reason of the international arrangements I mentioned, effectively one of these blanket licenses covers any broadcaster or communicator of music against any possibility of infringement. So in that sense, because APRA owns literally everything, it's a monopolist. It's the only seller in the market. Interestingly, however, the entities who need these blanket licenses also tend to be very large organisations. For example, the free-to-air television stations all club together into a collective entity called Free TV, and Free TV bargains with APRA about what the price to be paid for these blanket licenses are. But Free TV is the only purchaser in the market, so it's effectively a monopsonist. So what you have, and the reason you have the Copyright Tribunal is that the Copyright Act has basically created a bargaining situation between a monopolist and monopsonist, who are left to determine what the market price is. But of course there is no market price because there are only two participants, and that's the reason the Copyright Tribunal exists. It's just to determine the price when they are unable to reach an agreement. The proceedings of the tribunal can be quite hard fought. Can I just emphasise some similarities with Part 3A of the Competition and Consumer Act? What the Copyright Act creates is a right to obtain a licence to use the copyrights, which is effectively an access right owned by collecting societies, and it provides a regime for determining what the price of that access should be. In other words, it's an access regime with price machinery. And like Part 3A, the ultimate arbiter of the price-fixing machinery is an independent tribunal of government whose members are principally federal court judges. The same is also true of patents. There's an access regime for patents. Chapter 12 of the Patents Act provides for the compulsory licensing of patents that is the use of a patent without the patent holder's consent. There's a general scheme for this and a particular scheme for pharmaceutical patents. The general scheme, in essence, permits a compulsory licence of any patent where the patent holder is not using the patent in Australia, and it would be a public benefit if the patent were being used in Australia. Under the general scheme, it's the federal court which determines whether the patent in question meets the criteria for its application, and it's the federal court which works out the relevant terms. The scheme for pharmaceuticals is more complex but relevantly the same. Can I again point out that that scheme has the same features as Part 3A, and that is an access regime with a pricing machinery. So these systems of monopoly regulation work quite well, and certainly sufficiently well that very few people are aware that they exist. So can I then turn to some areas where the regulation of monopolies seems to me not to be working quite so well? And here I want to explore the idea that history repeats itself. If we just cast our minds back to the world of James I and Elizabeth I before the Statute of Monopolies, what were the characteristics which led to the profligate distribution of unsound monopolies? It was a form of executive government with a distaste for raising tax revenue through parliamentary means. What were the effects? The sale of monopolies raised revenue for the Crown, but it was the monopolists who bore the unhappiness of the price increases which resulted. In effect, the political undesirability of raising tax revenue forced the Crown into the surreptitious taxing of its own subjects via monopolies on ordinary goods such as wine and salt. These circumstances are, so it seems to me, are present in the practice of state governments in Australia in selling off various concessions. Can I start with toll roads? There's nothing wrong with road building, and indeed much of the road infrastructure in England was achieved through statutory trusts known as turnpike trusts in the 17th and 18th centuries. However, the very many acts which established individual turnpike trusts were petitioned for by local parishes who desired a road to be constructed. So far as roads are concerned, here in Australia we have four problems. First, since the first and second uniform tax cases, the states have given up income taxes and are largely therefore beholden to the Commonwealth for most of their revenue, either through state grants or through the distribution of GST revenues. Thus, political responsibility for spending money has become detached from political responsibility for raising taxes. This is the well-known constitutional problem of vertical fiscal imbalance. Secondly, the states are therefore constantly short of money since the Commonwealth has no real impetus to raise taxes. When it does not give New South Wales enough money to run its health system, it is the New South Wales government which gets blamed and not the Commonwealth. Thirdly, being short of money, a bit like Elizabeth I and James I, the state treasurers are constantly on the lookout for new ways to raise funds. Fourthly, we now have private entities who become exceedingly professional at building roads. What could possibly go wrong? The fundamental difficulty is that the state has an inherent conflict of interest in deciding whether a new toll road should be built. It needs the concession fees it gets from granting the road builder the right to build the road and levy the tolls. It's not surprising, therefore, that as the states have become more and more squeezed by vertical fiscal imbalance, there has been a blossoming, like mushrooms after rain, of toll road projects. Although we have the example of Los Angeles and New York before us to show that the answer to traffic problems is public transport, not road construction, the revenue problems the state faces cause them to favour toll road construction by the granting of concessions to toll road constructors. And just as was the case with the state of affairs before the Statute of Monopolies, the entities which bear the brunt of the public's unhappiness are the operators of the toll roads who get blamed each time there is a toll increase. Further, just as with Elizabeth, the reality is that the concession fees obtained by state governments for these toll road projects are, in economic substance, a public tax on road users disguised as private tolls. Similarly, but there may be similar, but perhaps much more pointed remarks can perhaps be made about the concessions granted by state governments to conduct gambling activities, such as online sports gambling and poker machines. It's not necessarily easy to identify the socially redeeming features of a system which exploits people with a medical condition of gambling addiction. I know arguments are made that sporting codes depend on gambling revenues and with them clubs and hotels, but if you're old enough, and I see that many of you are, you will remember precisely the same argument was mounted when the sporting codes, clubs and hotels made their money off the back of tobacco advertising. It's not obvious to me why gambling revenues stand in a different position to tobacco revenues when the public health issues are brought to account. So these are examples involving state-granted monopolies where the accompanying regulatory regime appears to be inadequate. What is present in the case of Part 3A, the Copyright Act and the Patent Act, is a scheme of monopoly regulation overseen by a body independent of government. This has been politically achievable because the Commonwealth itself has not had a stake in the revenues involved. In the case of state concessions for toll roads and gambling, this is not the case. The question of how states can be brought to the same insight that James I eventually was brought to when he assented to the statute of monopolies is a difficult question. There seem to be two possible solutions. The first is to solve the problem of vertical fiscal imbalance. This would involve a major constitutional alteration in which the Commonwealth lost power, and it hence seems to me to be extremely unlikely. The second is to use the economic powers that the Commonwealth does have to persuade the states that it's in their own interest to give up this kind of activity. The architecture for this second solution is sort of in place through the existence of a national competition policy, good compliance with which sometimes results in the states receiving big dollops of money from the Commonwealth. The good news is that these issues are on the radar of the Productivity Commission. Whether it will be able to overcome the political influence of those who benefit from the status quo is likely to take many years to determine. So that's what I wanted to say about monopolies. I hope I have not bored you too much. No.
Up there as well. Good evening, Your Honour, Chief Justices, members of the Stone family, esteemed guests. My name is Scott Donald and I'm an Associate Professor in the School of Private and Commercial Law at UNSW Sydney and an external consultant to Herbert with Freehills. It's my pleasure and privilege to deliver the vote of thanks today. I'd like to start by acknowledging the ongoing custodians of the various lands in which we all work and pay my respects to elders past and present. I also extend that respect to other Aboriginal and Torres Strait Islander people present here today. We have much to be thankful for today, on the occasion of this, the second Margaret Stone Lecture, at a time when much of the public discourse in this country seems sceptical of the relevance of universities to society. Events like this one are a powerful reminder of the symbiosis between the academy, the profession, and the bench. Margaret Stone embodied that symbiosis, making important contributions as an academic, as a partner in what was then Freehill, Hollingdale and Page, as judge on the Federal Court of Australia, and then in a succession of vital national security relevant roles, where naturally enough she earned a familiar moniker. We at HSF, and I dare say some others, often familiarly called her M. She seemed genuinely delighted at that allusion, refusing to confirm or deny that she had operatives with a 00 designation available to her should she need them. So, thanks first to Chief Justice Mortimer for inviting us to hold this event in the Federal Court tonight. Thanks also to the partners and staff of Herbert Smith Freehills, especially Danielle Kelly, who's there, and Mike Rousakis, whose enthusiasm for this event underpins its success. Thanks also to Margaret's family, a number of whom are here again tonight, for the second edition of this lecture. You were the foundation on which Margaret relied. Thank you for sharing her with us, and thank you for allowing us to continue to benefit from her example. And now thanks to His Honour Justice Nye Perram, the fruits of whose labours over these past weeks we've had the privilege to enjoy over the past 45 minutes. Your Honour's paper takes us across a span of 2,000 years, from the Han dynasty of China to the Hems Empire of George Street. On the way we encountered honest Henry VI, upright Queen Elizabeth I, and naturally Donald Trump, who probably doesn't often find himself in lists of that type. We encountered Beethoven, Prince, Sinead O'Connor and Frank Sinatra, wine, coal and salt, and wine, canals, railways and toll roads. Your theme, of course, was to re-examine the nature of monopoly, to identify the way in which the right to pursue some field of endeavour, and crucially to exclude others from that same pursuit, permeates not just what we today think of as competition law, but the origins of corporate law and also the field of intellectual property. The right to exploit such monopolies can be extremely profitable, of course, whether you are Jonathan Swift writing in the 18th century about Lilliputians, or indeed Taylor Swift singing about, well, whatever she sings about, I'm not sure. And that, you argue compellingly, is the challenge for the state. Realistically, can it extract a concession from the monopolist and simultaneously regulate that monopolist to ensure that the social utility of the activity can be harnessed? You challenge us to recognise that as, and I quote, an inherent conflict of interest. Of course, for many students of law, your honours name will forever be associated with Margaret's as a result of the magisterial judgment you jointly delivered back in 2012, which I now realise was quite a long time ago, with Margaret and Justice Paul Finn in Grimaldi and Chameleon Mining. Its 783 paragraphs are, for good reason, still regarded as the go-to source for guidance on conflicts of interest, that term again, fiduciary duties and accessorial liability in the corporate context. I'll leave to another time the question of whether today's students have actually read all 783 paragraphs, or whether they've started to avail themselves of, how should we call it, artificial assistance. On that, as they say, the jury is probably still out. So thank you, Judge, for your lecture tonight. We know there are many claims on your time, and we very much appreciate the energy, insight, and wisdom that you brought to the task. Thank you. And with that, I bring tonight's proceedings to a close. Thank you all for coming. We look forward to seeing you at the next Margaret Stone Lecture in 2 years' time, or maybe we'll see you before that at one of the many events we convene at UNSW Law each year. We'd like that. Thank you.